Welcome to A Life Without Parole. I'm Amy and I'm on assignment. I'm at a hotel actually, but I wanted to pop on real quick and give an update on Lori Vallow Daybell. Lori Vallow Daybell was charged in the state of Idaho and found guilty on charges of murdering or assisting in murdering her two children, Tylee and JJ, as well as murdering her fifth husband's wife, Tammy Daybell. And she'll spend the rest of her life in prison, a life without parole. But now she's in Arizona. She's been in Arizona since December of last year. She is accused of assisting in the murder of her fourth husband, Charles Vallow, as well as the attempted murder of her niece's husband, Brandon Boudreaux. This case has been moving slowly. She has not waived her right to a speedy trial. But her attorneys are saying there's so much information that they need extra time. So this is the problem. She doesn't like her attorneys. So she just filed an affidavit. I'm going to tell you about that in just a minute. But I find it interesting that when she just recently did a phone interview with her son, Colby, who's the only one that's still alive of her kids, and she had all kinds of excuses for all of the evidence against her. The problem is it didn't match up with the evidence, but it's almost like she believes her rhetoric if she tells it enough times and with enough enthusiasm. And no matter how ridiculous it is, I think that she believes people are going to believe her. Well, it doesn't add up. And so, would she really have done better to represent herself? Because in the case, she didn't get to speak. She didn't speak at all in her previous trial, other than at her sentencing when she gave a bunch of hogwash as a statement. None of it added up. It was so ridiculous. It's almost laughable. And of course, I was at that sentencing hearing, and I don't know, I just think that she has had a lot of years to come up with stories to match the evidence against her. And even with her stories, they just don't add up. Let me tell you what the affidavit says. This is recent. So the court has received and reviewed a motion to withdraw dated October 21st, 2024. Her attorneys that she has right now are requesting to be released, withdraw from her case. Her court-appointed attorneys. It is ordered withdrawing the attorneys of record and the Office of Public Defender from further representation of the defendant and appointing new attorneys through the Office of Public Defense Services for all further representation. These attorneys want out, and they're saying, Judge, please appoint new attorneys. But there's more to this motion. The court also received a motion from the defendant requesting she waive her right to recounsel, and she wants to represent herself. This was filed on October 16th, 2024. The withdrawal was filed on October 21st. The court will defer the defendant's request until the conclusion of pending Rule 11 process. So basically, the court is saying, I'm not going to rule on whether she can represent herself until I've ruled on whether these attorneys can get away from being her attorneys. It's an interesting change. We'll see what happens, and make sure you subscribe and ring that bell to all so that you will be updated when I put up new content, when there's breaking news like this. We'll see. What do you think? Do you think that Lori will get the right to represent herself? Everyone basically has that right. Will she be deemed incompetent? And in that case, because she's deemed incompetent, will she be incompetent to represent herself, therefore still have a public defender, but need to be deemed competent? The difference is, in Idaho, she was deemed incompetent, but there's nothing that gives you a right in Idaho, innocent by reason of insanity. That's not a plea in Idaho. So you just have to go until you're competent, and then your trial will resume. Arizona is different. So we'll keep you in the loop. I'll see you soon. See ya.